Latest Concora revelations: amnesty demands investigation by child abuse inquiry. Posted 22nd of July 2015. Latest revelations will only fuel public disquiet that Concora has been excluded from the one inquiry with a chance of getting at the truth. Amnesty International has repeated its call for the investigation into child abuse at Concora Children's Home in Northern Ireland to be included in the Westminster Child Abuse Inquiry. The amnesty call comes as previously undisclosed government papers reveal that the Belfast Boys' Home in Northern Ireland was at the heart of correspondence involving the security services. The papers also named former government figures alleged to have been involved in paedophile rings. These include the late Sir William Van Straabenzie, who was a government minister in Northern Ireland between 1972 to 74, when the allegations of a paedophile ring at Concora were first made by British Army Captain Colin Wallace and Sir Peter Hayman, former Deputy Director of MI6, who has been named by former Concora boy, Richard Kerr, as being part of an establishment paedophile network who abused him after he was trafficked to London. Allegations have persisted for decades that a paedophile ring at Concora Boys' Home in East Belfast was linked to the British intelligence services. 2 former military intelligence officers, including Wallace, have alleged that the security services blocked police investigations into the child abuse in the 1970s.
Sir Peter Hayman is named by an MP as the diplomat whose diaries were mentioned in a child pornography case, and there's controversy about this use of parliamentary privilege. The name of Sir Peter Hayman, a former High Commissioner in Canada, was revealed, despite strong advice from the Attorney General, in 2 parliamentary questions tabled by Conservative MP Mr. Geoffrey Dickens. They asked if Sir Peter was to be prosecuted for sending pornographic material through the mail, and if security implications raised by his diaries would be investigated. They're due to be answered in writing tomorrow, but Liberal leader Mr. David Steele voiced what appeared to be the feelings of many members of the House when he suggested to the Speaker that this use of parliamentary privilege was a very dubious precedent. Gavin Hewitt has been looking at the background to the questions.
The naming of Sir Peter Hayman on the Commons order paper will inevitably raise questions as to whether a man with a distinguished career in the diplomatic service could have become a potential target for blackmail. In the 1950s, he served on the British delegation to NATO. By 1964, he was Deputy Commandant to the British military government in West Berlin. By 1970, he was submitting his credentials to the Canadian Prime Minister Pierre Trudeau as the new High Commissioner, a post he remained in until he retired in 1974. 2 years ago, Sir Peter appeared on the television programme Mastermind. He had listed his recreations as shooting, fishing and travel. He's a member of the MCC and 2 London clubs, the Army and Navy and the Travellers. He's also governor of International Student House in London. Police were led to Sir Peter's London flat after they found a package of pornography which had been left on a bus. From material discovered at the flat, the police prepared a case which was forwarded to the Director of Public Prosecutions, Sir Thomas Hetherington. He decided against prosecution because there was no question of financial gain or sending material to people who didn't want it. Tory MP Geoffrey Dickens said that one of the reasons he had named Sir Peter in Parliament was to remove the possibility of future blackmail. The wisdom of such action hasn't been shared by all MPs. Sir Peter Hayman lives at a Georgian house in the village of Checkenden in Oxfordshire. He's married with a son and a daughter and is said by relatives to be away on a motoring holiday in the south of France. Both he and his wife were active in the community, and in a village that is close-knit, the naming of Sir Peter in Parliament has left people in disbelief. Both he and his wife were regular churchgoers, Sir Peter being a sidesman until he resigned recently.
Well, I think in any community, do we really know our neighbours? But I think within the community, Sir Peter was a man who was very well liked and, contributed very much to the community.
How was he regarded in the village?
Well, I think he was well liked, and his wife with him, and they together both joined in many village activities.
There was considerable concern in the House of Commons today about the naming of Sir Peter. Tory MP Cyril Townsend said, if he's committed any offence, the law must take its course. If not, he should not be hounded by politicians. And Liberal leader David Steele warned about bandying names about in the chamber, which would create a very dangerous precedent. The Speaker replied that he had studied today's order paper with special care because of the publicity there had been.
The House is also aware that the privilege of free speech and protection which we enjoy in this house is our most cherished possession. It's the one that gives real significance and power to this house. And therefore there is a special obligation on us all to make sure that we never abuse that privilege. The questions referred to by the right honourable gentleman were technically in order. Otherwise they would not have appeared on the order paper. And I can really say no more.
There's been no word from Sir Peter Hayman direct today as regards his attitude to what's occurred in the House of Commons. His solicitor is Sir David Napley, who was asked whether Sir Peter was aware of the events now surrounding him.
He is aware. He knows about it, because he's spoken on the telephone. He's abroad at the moment, but has spoken on the telephone.
Was he aware that this was going to be raised in Parliament, though?
Oh, I don't think he... No, I'm sure he wasn't aware of that, no.
Has he any views about the way it has been done?
Well, I don't know what his views are, because I haven't canvassed them. I know what my views are. I think that naming him in the House of Commons was irresponsible. And the reason I think it's irresponsible is this, that I've always understood, and I gather the Attorney General said so, that there's been a convention in Parliament that you do not accuse a person of criminal offences unless they have been prosecuted or unless his name has been disclosed in a public inquiry. Well, now, I can well understand that there are circumstances in which it is necessary to raise matters in the House in public. But it is important to remember that in this case, a competent and responsible authority, knowing all the facts, such as they were, had decided that there shouldn't be a prosecution.
Allegations of child sexual abuse linked to Westminster investigation report. H3 Sir Peter Hayman. Peter Hayman was born in 1914. He married in 1942 and had 2 children. He held a number of important roles in the diplomatic service. Between 1964 and 1966 he was with the British military government in Berlin. Between 1966 and 1969 he was Assistant Under Secretary at the Foreign and Commonwealth Office. Between 1969 and 1970 he was Deputy Under Secretary of State at the Foreign and Commonwealth Office. And between 1970 and 1974 he was the British High Commissioner in Canada. He was knighted in 1971. He retired in 1974 and died in 1992. There were allegations Hayman had been a member of Pi using an assumed name, and that he had been sending and receiving through the post obscene material, for which he was not prosecuted. There has been long-standing public concern whether the decision not to prosecute Hayman either for his involvement with Pi or for sending obscene material through the post might have been politically motivated. Those concerns were first expressed in the House of Commons by Geoffrey Dickens MP in 1981, but they have continued to be aired ever since. One of the investigating police officers in the Hayman and Pi cases, Brian Collins, now retired, made a series of allegations to the Independent Office for Police Conduct, IPC, to the effect that the prosecution of Hayman was dropped inappropriately, that Hayman's name was intentionally kept out of the trial of other Pi members which did go ahead, and that Hayman unsuccessfully attempted to bribe Brian Collins and his fellow police officer. These allegations formed the basis of IPC investigations. The police investigation. In about 1974, Brian Collins joined the Obscene Publications Squad at Scotland Yard as a police sergeant, PS. His role was to investigate the production and sale of pornography. As a result of a News of the World article, an investigation was commenced into Pi which focused on Tom O'Carroll, one of the group's organizers. P.S. Collins and his partner, Police Constable, P.C. Dave Atkins, were in possession of a list of members of Pi, from which they selected for interview a dozen or so of probably the worst individuals, based on their correspondence with Pi through Magpie, Pi's publication, indicating their desire in connection with sexual activity with children. It was by those means P.S. Collins and P.C. Atkins put together a case against O'Carroll for conspiracy to corrupt public morals. One individual selected for interview on the list was a member of Pi called Peter Henderson. In a police report titled, Hayman and others, date stamped as received by the Director of Public Prosecution's Office on the 7th of December 1978, P.S. Collins set out the facts. A quantity of obscene photographs and correspondence, sent through the post to an individual named Peter Henderson at 95 Linden Gardens, London, W2, was found on a bus on the 21st of March, 1978 by a member of the public and handed in to the police. The officers discovered Henderson was a member of Pi, which consists of people who advocate sexual acts between adult and child. They went to the address on the 2nd of October, 1978, where they were let in by the managing agents, and a locked wardrobe was forced open. In it, on shelves, were 45 volumes of photographs and writings, each of about 200 pages, which contained a record of sexual activities over the previous 6 years. The report states, "These records contain nothing but obscenities on every conceivable sexual act, deviation and perversion, are a complete, specific record of Henderson's sexual acts with other men and women, both pictorially and of written matter. Trophy items were pressed between the leaves of the volumes, and other items were found fixed to the wardrobe." When Henderson arrived at the flat that day, the officers spoke to him. He accepted all the items were his and that he had been engaged for many years in exchanging obscenities through the post with others. He made a short statement under caution. It was obvious to the officers that he was not who he claimed to be, but at no time did he reveal his true identity. A few weeks later, a briefcase containing various obscene writings and photographs was found and handed in to police. The IPC Operation Hesper closing report refers to this. It was found in St. James's Park by an officer of the Royal Parks Police with Metropolitan Police dog handlers. Documents inside the briefcase named Peter Hayman. Also found were envelopes containing black and white photographs of boys aged between 8 and 11 dressed only in their underpants. Mr. Collins said he did not recall this. Henderson was seen again by police on the 24th of October 1978, when he identified himself as Peter Hayman. He identified the briefcase and its contents as his, saying it had been stolen from his car some weeks earlier. In the police report, P.S. Collins wrote, "Many of the obscenities written in Hayman's books referred to children, and although it was reasonable to assume that much of it was fantasy, further inquiries were made in this direction." Other parts of the police report mentioned children. Some of the images circulated among Peter Hayman's correspondence were normal snaps of children, but pages from Hayman's records for 1975 included a photograph of an 11-year-old girl with obscene comments written about her. The circle was Hayman's description of those with whom he corresponded. In relation to a family Hayman had become involved with, the report states. Although the sex volumes contain references to the children, there is no evidence to suggest they have been involved in any way in this matter apart from being fantasized about by Hayman and other members of the circle. The report states Hayman had made contact and corresponded with a man, ciphered as WM-F24/Pi. WM-F24 was in possession of a quantity of obscene material relating to young children. He also had 2 photographs of naked young girls which Hayman had sent to him. Robert Wardell was a bus inspector and a Pi member. He and Hayman had established contact and exchanged obscene letters through the post. In the report, P.S. Collins wrote that Wardell had sexual fantasies which were the most horrific and sickening accounts of sexual desires that one could possibly imagine. He has a consuming passion for the activities supposedly carried out by the German SS towards Jewish children. These incredibly sadistic accounts of atrocities directed towards children he has sent to Hayman, who, just as incredibly, enjoyed them. Wardell also sent Hayman photographs of children fully clothed. A retired headmaster, John Sewell, was a member of Hayman's circle. He had convictions for indecent assault of young boys. He was spoken to by police in relation to the Pi Inquirer, when he denied association with an advert in the Pi contact sheet advertising an interest in little girls in white pants, and little boys without them. Sewell had sent Hayman 2 photographs of young girls showing their underwear with obscene comments on them. Sewell had further similar material in his possession. Another correspondent, ciphered as WM-F25, sent letters to Hayman through the post which related to sexual activity with young boys. The report states, although they will be claimed to be fantasy, WM-F25 admitted when seen originally that he had indecently assaulted a young boy some 5 years ago. In light of this, Mr. Collins was asked in the course of his evidence why he had felt that Hayman's writings in relation to children were fantasy. He said it was because they were so extreme. In some instances, he said, Hayman was referring to well-known people as well as friends of his family. He added, it was obvious that some of the stuff, or most of the stuff, no, not most, some of it was fantasy. He said there was no evidence to charge Hayman with any offense of child sexual abuse. He was asked what further inquiries had been made in relation to Hayman's writings about children. He recalled visiting some addresses where there were families with children. In a subsequent and very lengthy police report which focused on the activities of P.S. Collins noted that Hayman, using the assumed name Henderson, had corresponded with in the person of David Grove, seeking advice about progressing a sexual relationship with a little girl. In light of this material, and Hayman's association with Mr. Collins was asked whether, at the time, the police could have had confidence that Hayman was not in fact a pedophile. His response was, I can't see how anyone would say that. I think he would have grasped at any opportunity to take advantage of man, woman or child sexually. P.S. Collins concluded his first report by remarking that Hayman had a great deal to lose by reason of his position in society, but the sheer filth spread far and wide by him, particularly its content with regard to the sexual and physical abuse of children, must place him in the category of being one of the worst offenders in relation to sending obscene material through the post. The Director of Public Prosecution's decision not to prosecute Sir Peter Hayman. P.S. Collins expressed the view in his report that offences had been committed under Section 11(1)(b) of the Post Office Act 1953, which provided, a person shall not send or attempt to send or procure to be sent a postal packet which, b. encloses any indecent or obscene print, painting, photograph, lithograph, engraving, cinematograph film, book, card or written communication, or any indecent or obscene article whether similar to the above or not. The sentence for conviction on indictment was imprisonment for not more than 12 months. He told us in evidence that he recalled receiving a phone call from Sir David 𝗍𝗶𝗁, who was Peter Hayman's solicitor. He asked him if he was dealing with the Hayman case and then asked him who was dealing with it at the Director of Public Prosecution's office. Mr. Collins knew it was Jeremy Naunton, as he had been talking to him about the dates of charges. He did not wish to land Mr. Naunton with a call from Sir David 𝗍𝗶𝗁, and so he told Sir David he would find out and get back to him, to which Sir David replied, "Don't bother. I'll talk to Hetherington." Sir Thomas Hetherington was the Director of Public Prosecutions at the time. It was, said Mr. Collins, the next day that he and his partner were called into Chief Inspector Shepherd's office to be told that Hayman was not to be prosecuted but cautioned instead. Mr. Collins said he was never told why. It was not until he read material in advance of giving his evidence to the inquiry that he learned that Hayman had been claiming to be suicidal. Mr. Collins remarked that being suicidal had not prevented Hayman from appearing on Mastermind or subsequently importuning a lorry driver in a public toilet. Hayman subsequently accepted the caution, so he admitted the offending. Jeremy Naunton was a solicitor who began working in the Director of Public Prosecution's office in around 1971. Following the submission by P.S. Collins of his police report on the investigation into Hayman, and its receipt by the Director of Public Prosecution's office on the 7th of December, 1978, an interim advice note was written within the office. Mr. Naunton told us he thought the advice note was probably my note. He recognized the handwriting at the end of the note as his. The note was addressed A.D. Met, which was an abbreviated reference to the Assistant Director of the Met Division, who was Mr. Naunton's line manager. The note stated that, like most of Scotland Yard's investigations under Section 11 of the Post Office Act 1953, this case left a lot to be desired and it is difficult to make a decision without seeing the original photos or the latest letters. Mr. Naunton said he had not seen any of the original exhibits, and therefore no decision could be made until they were available, though the idea had been to progress the case towards a prosecution. He wrote that despite the theme of pi running through the papers, there was no evidence to suggest that any of them have committed offenses with children. He added, "Whilst we are shortly to receive a full report on the activities of pi, I am told by the police that this is an independent offshoot that can be dealt with separately. I hope that any decision we make here will not be a rod for our own backs when the pi case arrives." This cautionary note was rather prescient in light of P.S. Collins' later report on pi, which noted Hayman's correspondence with the David Grove about his sexual desires involving a little girl. Mr. McGill remarked this was a salutary reminder to all prosecutors that, before making a decision, you need to have all the facts at your disposal. Because if you do it too quickly, there could be material that may materially affect the decision you've made. In his advice note, Mr. Naunton recorded that the police were anxious that proceedings were taken against those named and possibly for conspiracy to contravene Section 11 of the Post Office Act 1953. The articles found in Hayman's flat were obscene and indecent, and must have been sent through the post. There was no organized general postal distribution of obscene articles. While Hayman's articles were obscene, they did not appear to fall within the usual categories under the Obscene Publications Act, because although money did pass, there was no real arrangement for a financial gain to be made. He added the activities described were for the personal and private sexual benefit of the individuals, some of whom had been known to each other for years, and not for indiscriminate circulation. Thus, he noted, the case fell into a lower category than others they saw and could possibly be dealt with by individual substantive charges under Section 11 of the Post Office Act 1953. Mr. Naunton told us there had been no policy in the Director of Public Prosecution's office when considering Post Office Act offenses or Obscene Publications Act offenses. Obscene Publications Act offenses required the person to publish or have an obscene article for publication for gain, whereas the Post Office Act was, he said, aimed at the protection of post office employees and was slightly obsolete. In the view of Mr. McGill, the decision not to prosecute Hayman under the Post Office Act 1953 was reasonable given the offense was considered to be outdated. It was aimed at protecting post office employees, and so the circulation of the material had not harmed those it was designed to protect. The material was circulated among like-minded adults, and there was no intention to make any financial gain from it. Mr. Naunton's advice note went on to consider each of the suspects, beginning with Hayman. Mr. Naunton noted that Hayman had admitted being a member of pi for a while about a year ago, and in his statement under caution he had said he disagreed totally with pi's views. When later questioned about his relationship with pi, Hayman had said, "I wish you to believe that I have never interfered with children. All I have written about is pure fantasy. I suppose I know I should never have sent those things through the post, but I never really thought about it." The advice note concludes with Mr. Naunton observing, "No one can really support what the defendants have been doing, but I consider that the police are making a storm in a teacup. As far as I can see, subject to WM-F25, no child has been affected by their group activities and no one has been offended by seeing any obscene writing through the post." As for the suggestion that Hayman's writings about children were pure fantasy, Mr. McGill told the inquiry that, today, in such circumstances, he would expect prosecutors to consider the offense under Section 1 of the Obscene Publications Act 1959 of publishing obscene material. In particular, where there did not appear to be any evidence of contact abuse offenses against children, fantasy discussion of abusing children can fall within the definition of obscenity, and can also be captured by the offense. Mr. Naunton denied knowledge of P.S. Collins' later report on pi, and said the decision to caution had not been his, but had it been, he said he would have taken into account the information in the pi report in deciding on charge. He added even though Hayman had been cautioned, there was no reason why he should not have been prosecuted for any other offenses disclosed in the later report. Mr. McGill agreed. Mr. Naunton had questioned in the advice note whether there was any useful purpose in prosecuting any of the possible defendants, as no harm had been done to anyone, but if proceedings were to be instituted he advised substantive charges under Section 11 of the Post Office Act 1953. He made clear that his opinion was based on the papers and what he had been told by the police. In evidence he said that he had not been considering the public interest but the evidential test only, i.e., whether there was a reasonable prospect of conviction, which was the test before the Code for Crown Prosecutors. He said that consideration of public interest factors would probably have gone up higher because of Hayman's background. Mr. Collins gave evidence that, before the decision was made to caution him, Hayman had turned up at Scotland Yard to speak to him and P.C. Atkins, and had tried bribing them with £25,000 each. Mr. Collins recalled telling him not to be so stupid as he was in enough trouble already. However, either officer reported the bribe because, said Mr. Collins in evidence, Hayman did not actually try giving them any money. Mr. Collins recalled but rejected the criticism in the Operation Magnolia report that they did not follow Metropolitan Police policy. Mr. Collins told us that he had not considered that Hayman's approach had amounted to perverting the course of justice, which might have strengthened the case against Hayman on the other offenses. Mr. Collins said Hayman was in a terrible state, by which he said he meant his whole family, his future. It was diabolical for the man and his family that it should come to light. He said he was sympathetic towards him in that sense. In Mr. Naunton's view, if the bribe had been a genuine offer it ought to have been reported. He agreed it would have been taken seriously but said he had no idea if it would have led to a further investigation or charge. He was not prepared to be drawn on whether a substantial sentence of imprisonment would have followed a conviction for perverting the course of justice in such circumstances. Mr. Naunton told us he had later become aware that a meeting had in fact taken place between Sir David Napoli and the Director of Public Prosecutions, but had known nothing about it at the time and was not invited to attend. Mr. Naunton would not say whether a meeting between a suspect's solicitor and the Director of Public Prosecutions was normal but asserted that the Director of Public Prosecutions had control over his office and could decide whether to meet Sir David Napoli. Mr. Naunton said he had no idea if anyone else had been in attendance, or if minutes of the meeting had been taken. He did however accept that, in all his time as a solicitor in the Director of Public Prosecutions office and then the Crown Prosecution Service, he had no experience of the Director of Public Prosecutions entertaining a suspect's solicitor and coming to a resolution of a case. The impression we are left with is this was an exceptional if not unique occurrence. Mr. Naunton said he had never discovered the reason why Hayman was cautioned. He was asked why at the end of his advice note he had written, "I am told by Sir David Napoli that Hayman has suicidal tendencies because of the case." He claimed Sir David Napoli might have wrung him, and it was merely his assumption that his suicidal tendencies was the point that was raised with the Director of Public Prosecutions. He thought he annotated the advice note before Sir David Napoli had seen the Director of Public Prosecutions. He could not recall P.S. Collins ever tipping him off that Sir David Napoli might call. He accepted the possibility that Sir David Napoli had discovered his name and had spoken to him about Hayman. He did not accept participating in the decision to caution. He said he might not have taken an enormous amount of notice of what he had been told about Hayman's suicidal tendencies, unless he had received some psychiatric evidence because, as he put it, those who claim to be suicidal tend not to act on it. He did not know if the Director of Public Prosecutions had been provided with any psychiatric evidence to support the claim that Hayman was suicidal. He was not prepared to agree that the decision that was taken was highly charitable. For his part, Mr. McGill thought that any suggestion that a person arrested for crime is suicidal had to be treated with some skepticism. Faced with such a claim today, the Crown Prosecution Service would expect to see some medical evidence in support, and for a serious offense, would ask that the suspect be examined independently by a psychiatrist instructed for the prosecution. It would not be accepted at face value. Wardell and Norris. On the 2nd of October 1980, Robert Wardell and a co-accused John Norris pleaded guilty at St. Albans Crown Court to an offense of conspiracy to infringe the provisions of Section 11(1)(b) of the Post Office Act 1953. The particulars of the offense in the indictment were that, between the 1st of January, 1975, and the 18th of April, 1979, They conspired together unlawfully to send packets to each other containing obscene written communications, namely sadistic accounts of the sexual torture and killing of children. They were conditionally discharged for 3 years and ordered to pay costs. John Sewell was not charged with Wardell and Norris, but he became a witness in Tom O'Carroll's trial. Following a retrial at the Central Criminal Court, Old Bailey, on the 13th of March, 1981, O'Carroll was convicted of conspiracy to corrupt public morals in the Pye case and was sentenced to 2 years' imprisonment. Mr. Collins distinguished the way Peter Hayman and Robert Wardell were treated. Hayman, he said, had the services of Sir David Napoli and was not prosecuted, yet Robert Wardell, a bus inspector, was prosecuted on exactly the same material. The IPC Operation Magnolia report noted that Wardell had been charged due to the serious and extreme nature of the content. Mr. Collins said he thought there was one law for Wardell and another for Hayman. It was obvious that Mr. Collins remained greatly affected by the decision in the Hayman case. Mr. Naunton did not know whether Hayman and Wardell had received differential treatment, or whether the outcome in Hayman's case could be explained by him being shown undue deference. He said, "I wasn't responsible, as far as I know, for the prosecutions of those two people." Mr. Naunton then remarked, "The taller they are, the harder they fall, and Hayman was fairly tall in respect of the diplomatic side of it. Therefore, he had a lot to lose. I'm not saying the others didn't, but he had a lot to lose if he was prosecuted." Mr. Naunton told us he did not think that the decision in Hayman's case had anything to do with showing him undue deference. He thought that the decision was made due to the serious risk that Hayman might commit suicide because of his position in society. The political fallout. On the 24th of October 1980, Private Eye exposed the Hayman case in an article entitled, "The Beast of Berlin." It reported that his role had emerged after 2 men were conditionally discharged for 3 years after pleading guilty to sending obscene material through the post. The decision not to prosecute Hayman, who was certainly as guilty as these 2 unfortunates, came from high up, much to the disgust of DPP Tony Hetherington's aides and also the policemen involved in the case. The 2 unfortunates were Wardell and Norris. Lord Armstrong told us that neither the Foreign and Commonwealth Office, the Cabinet Office, nor the Security Service knew anything about the matters in the article until it was published. In a minute of the 27th of October 1980 from Lord Armstrong, then Cabinet Secretary, Sir Robert Armstrong, to the Prime Minister, he drew attention to the Private Eye article and made reference to the Collins 1978 police report, including the fact Hayman was a member of Pi. He observed that the only sexual activity that could be shown to have occurred was with consenting adults, and there was no evidence for actual activities with children. Private Eye published a second article on the 7th of January, 1981 claiming there had been a flaming row between the Director of Public Prosecutions and the Attorney General. On the same day, the Director of Public Prosecutions produced a memo saying that he was not aware of any disagreement between the Attorney General and himself. Lord Armstrong told us that assertion related to the Hayman case. He said that he had been wrong to say in his witness statement that the Director of Public Prosecutions had been minded to authorize a prosecution but had been overruled by a higher authority, and that the Attorney General had in fact accepted the Director of Public Prosecution's advice not to prosecute. In another memo to the Prime Minister, dated the 9th of January 1981, Lord Armstrong discussed security service inquiries thus far and the need once they were over for the security service to speak to Hayman himself. Those inquiries involving colleagues had revealed 2 instances of concern when Hayman had been in Baghdad and Ottawa, but Hayman gave his colleagues no cause to suspect that he might be engaged in irregular sexual activities. Lord Armstrong said he could not recall if, by the use of that term, Hayman's colleagues were aware he was engaged in irregular sexual activities. Lord Armstrong said he thought he had been referring to Hayman's general activities as described in his diaries, and the term did not mean sexual activity with children, but irregular sexual activities outside marriage. The Security Service MI5 had indeed been involved in making inquiries. They had first become involved within days as a result of the first Private Eye article. The MI5 witness told us about MI5's interviews with Hayman, in which he denied reports that local boys had visited his house in Baghdad, saying, "I am not interested in boys." Hayman said he had been given immunity from prosecution by the Director of Public Prosecutions on the ground that his offense did not warrant such punishment, adding, "I have been punished by the press." The MI5 witness was unable to interpret Hayman's use of the word immunity other than to say that it normally meant an assurance not to prosecute a person if they do something. Mr. McGill agreed, saying that there was nothing in the material he had seen to suggest Hayman was given any immunity, and that the word is sometimes used by suspects to mean that because a decision has been taken that they will not be prosecuted on particular facts, that is usually an end to that matter, and they are unlikely to be prosecuted on the same facts in the future. The MI5 witness told us that the outcome of the investigation was, while Hayman had rendered himself vulnerable to pressure by a foreign intelligence service, there had been no actual prejudice to security. Peter Hayman's name had been inadvertently mentioned during the 𝗖𝗆𝗏𝗃 trial. The Director of Public Prosecution's memo of the 7th of January 1981 noted that the first 𝗖𝗆𝗏 trial was to commence on the 14th of January 1981, adding that Hayman was never considered to be an organizer, and is not involved in the prosecution, although the possibility that his name will be mentioned cannot be excluded. A background note of the 17th of March 1981 from the Law Officers Department, now the Attorney General's Office, stated there had been no policy that Hayman's name should not be mentioned in the Pi case, or, if mentioned, only under his assumed pseudonym. The note added that Hayman's name had cropped up at the committal proceedings and he was then referred to by the name under which the witness being examined knew him, which was normal practice. Hayman was not called as a witness, and it was understood that he was not referred to by the prosecution at the Crown Court, and the defense had only made reference to a senior civil servant. Mr. McGill understood from the material he had read that during the 𝗖𝗆𝗏 trial Hayman had been referred to as Peter Henderson. He had seen nothing to suggest there had been any positive decision not to name Hayman. The parties only knew Hayman by his alias, and it was likely they referred to him that way for the sake of consistency. Newspaper articles in The Guardian and The Times on the 7th of April, 1981 show that Sir Michael Havers, the Attorney General, denied Hayman had received special treatment, and explained that Hayman's name had not been mentioned in the 𝗖𝗆𝗏 trial because witnesses only knew him as Henderson, and because he was not directly involved in the case. There is no evidence of the existence of any arrangement not to name Hayman during the 𝗖𝗆𝗏 trial, and it is implicit from the sentence quoted from the Director of Public Prosecution's memo of the 7th of January, 1981 that there was none. Fearing an establishment cover-up and using parliamentary privilege, on the 18th of March, 1981, Geoffrey Dickens MP publicly named Sir Peter Hayman in written Commons questions as being the diplomat referred to in 𝗖𝗆𝗏𝗏's Old Bailey trial. He asked about the security implications Hayman's activities might have posed, and if the Attorney General would prosecute Hayman for sending and receiving pornographic material through the Royal Mail. The Attorney General's written answer provided on the 19th of March, 1981 was that the Director of Public Prosecutions had advised against prosecuting any of the persons under the Post Office Act 1953 or for any other offense, and that among the considerations he took into account were the factors that the correspondence had been in sealed envelopes passing between adults in a non-commercial context, and that none of it was unsolicited. A further report had shown that 2 others had shared an obsession about the systemic killing and torture of young people and children, and the Director of Public Prosecutions had decided to prosecute them for conspiracy to contravene Section 11 of the Post Office Act 1953. A clear reference to Wardell and Norris. The Attorney General added Hayman had never sent or received that kind of material through the post, yet P.S. Collins' police report said Hayman had in fact received sadistic accounts of atrocities directed towards children, and that he enjoyed them. Insofar as Pi was concerned, the Attorney General said Hayman had never been involved in Pi's management. The Attorney General said he was in agreement with the Director of Public Prosecutions not to prosecute Hayman and the other persons with whom he had carried on an obscene correspondence. Undue deference. In his oral closing submissions on behalf of the complainant court participants, Mr. Richard Scorer submitted that the Director of Public Prosecutions had dismissive attitudes towards child sex offending, as illustrated by the Montague and the Hayman cases. It was, Ms. Johnson QC argued, an age of deference and an age when victims were not placed at the forefront of the criminal justice system. She suggests we cannot safely conclude that the decisions were taken because the accused were members of the establishment rather than because as defendants their interests were placed above those of their victims. Indeed, at the end of his evidence, the chair asked Mr. Collins if there was a general sense at the time that possessing indecent images was a victimless crime. Mr. Collins said there were different attitudes then, and children did not take precedence. A newspaper article written by Ronald but appeared in the Times of the 26th of March, 1981, in which Sir David Napoli was quoted as justifying the decision in Hayman's case not to prosecute, on the quite different grounds that a customary factor taken into account when deciding whether to prosecute was whether the indirect punishment and hardship which a defendant may suffer is likely to be so disproportionate to the severity of the alleged offense and to any penalty imposed by a court that it would be unjust to prosecute. This, Sir David asserted, was overwhelmingly the situation in Sir Peter's case and manifestly justifies the director's decision. On the contrary, far from justifying the DPP's decision, the excuse condemns it. If a man is to be excused the due process of law, other things being equal, because he is well known, then we are indeed in a two-nation society. The 17th of March, 1981 background note from the Law Officers Department, which was written in anticipation of Mr. Dickens publicly naming Hayman, also states, "The first decision not to prosecute Sir Peter Hayman was based on policy, and his 8 potential co-accused were also not prosecuted under the same policy. He was never seriously under consideration as a potential defendant in the second case. His former position was not a factor taken into consideration in reaching these decisions, and no attempt was made to cover up the facts to save either him or the government embarrassment." There is no mention in the background note of Hayman's claimed suicidal tendencies or that the first decision resulted in a caution. This is a surprising omission if Hayman's suicidal tendencies played a part in the Director of Public Prosecution's decision not to prosecute, but only to caution him. If the risk of suicide played no part in the decision, the question arises why Hayman was not prosecuted and only cautioned following a private meeting between Hayman's solicitor and the Director of Public Prosecutions. Was the disposal in his case due to some prosecution policy as suggested in the law officer's note? Mr. Naunton told us there was no prosecutorial policy under the Post Office Act 1953. It suggests that no faith can be had in the accuracy of the law officer's note of the 17th of March, 1981, when it claimed that Hayman's former position was not a factor taken into consideration and that no attempt was made to cover up the facts to save him or the government embarrassment. Moreover, the quotation in the Times from Sir David Napoli did not seek to justify the decision in Hayman's case as based on the risk of suicide. In fact, Sir David was not quoted as making any mention of Hayman's alleged mental state at all. The implication of his justification of the Director of Public Prosecution's decision is that Hayman was a special case because he had suffered a very public fall from grace. The evidence leads to the firm impression that Hayman was indeed the beneficiary of preferential, differential, and unduly deferential treatment as a person of public prominence. We sympathize with Mr. Collins' view that 𝗲𝗏𝗱𝗏𝗏𝗏, who was a bus inspector, was prosecuted for sending the most seriously obscene material to Hayman, while Hayman, who was the recipient of it from 𝗲𝗏𝗏𝗏, was only cautioned. If P.S. Collins' 1978 report about Hayman having received that material from 𝗲𝗏𝗏𝗏 is accurate, and there is no reason to think otherwise, then the Attorney General's answer to Mr. Dickens on the 19th of March, 1981 that Hayman had never received that kind of material through the post was incorrect and misleading. Ms. Johnson was right to decry the access Sir David Napoli had to the Director of Public Prosecutions. It is difficult to imagine less well-known solicitors for less well-known clients being given the same level of access. She argued that it did not mean there had been a cover-up but that it was more indicative of the old boys' network. It is now clear that 𝗲𝗏𝗏𝗏 was prosecuted for sending through the post the very kind of seriously obscene material Hayman had received from him. Based on all the evidence, it is clear that, because of his prominent position, Hayman was able to engage in special pleading for which he received special treatment, to which he referred in his later interview with MI5 as immunity from prosecution. Trudeau Heath talks on world affairs. Trudeau Heath talks on world affairs. British Prime Minister Edward Heath says goodbye to his Canadian counterpart Mr. Pierre Trudeau Deft, after their meeting at Mr. Trudeau's official residence in Ottawa. With them is the British High Commissioner to Canada, Mr. Peter Hayman. The private talks on Sunday between the two. On screen is the link to gain access to the image. Because that specific Reuters photograph from January 2, 1973, is not hosted on any open digital image platforms, there is no active hyperlink available to view the image of Prime Minister Edward Heath, Pierre Trudeau, and Sir Peter Hayman together. As recorded in historical news indexes like the Straits Times Archive, the photo caption confirms the wire photo exists in physical microfilms. However, it has never been digitized or uploaded to public stock photo repositories.